Hello, Namaskara, good evening, and welcome to BIC Streams. Today's session, Criminal Law Reforms, A Dusty Road, will discuss recent developments and contemporary challenges, as also whether the law adequately protects the rights of all the stakeholders of the system, the accused, the victim, and the society in general. Our discussants today are Justice R. Basant, Vrinda Grover, Isha Pant, and Mrinal Satish. Satish, who will help us navigate this labyrinthine but essential and urgent conversation. The bios of all the speakers will appear in the chat box, which is on the bottom of your screen. And please feel free to pose any questions or post comments through the conversation through the Q&A box, which is also on the bottom of your Zoom screen. And with that, over to Mrinal.
Thank you, Lekha, and thank you to BIC for organizing this important discussion on a topic that all of us, as the general public, also have views. So whenever we discuss criminal justice reforms, I think, and I'm sure my fellow panelists will agree, is always an evergreen topic because crime is something that interests everyone. I think the 2020 showed us with the entire Sushant Singh Rajput, I don't know what word to describe it, circus or whatever happened, that how much people are interested in crime, but at the same time we are interested in our own protection from crime, which makes criminal law something that I think the world is interested in. And in that context, in our interaction with the criminal justice process, we also have a lot of questions, I suppose, as the general public about its working, whether there's a need for more changes, and we keep hearing of changes. Now, just to provide context, if we were to define the criminal justice system, and again, this is for the listeners, we would generally include the Indian Penal Code of 1860, the Criminal Procedure Code of 1973, and the Indian Evidence Act of 1872. Although it's not a criminal legislation, we rely on the Indian Evidence Act for most of the work we do in the context of the criminal process. We would also include various special criminal enactments dealing with particular acts, such as the Narcotic Drugs and Psychotropic Substances Act, the Protection of Children from Sexual Offences Act, the Prevention of Money Laundering Act, the Unlawful Activities Prevention Act, and many, many more. We also have laws which have chapters or sections which deal with, which have criminal provisions. For instance, the IT Act has an entire framework of how to deal with information technology, and the offences chapter, which was introduced later, has the offences that we are concerned with when we talk about the criminal justice system. And a lot of these so-called special criminal legislations sometimes provide a framework which is different from the IPC, Cr.P.C, and the Indian Evidence Act. So a lot of talk on criminal justice reform tends to look at whether we need special laws for special situations that are emerging, something that we will discuss also today. So amendments to criminal laws generally tend to be reactionary and sporadic. For instance, much needed amendments to the Indian rape law happened in 2013 as a reaction to the Delhi gang rape and homicide case. Many of the demands for change had been made for the previous 30 years after the 1983 amendment, which was also reactionary in reaction to the Mathura rape case. But those changes had not been made. And as someone who analyzes criminal law, I feel that those amendments would not have happened if not for the 2012 incident, because there was no political capital for the legislature to actually amend the laws. And similarly, there have been multiple committees set up over the years to look at criminal justice reform. The Law Commission of India has multiple reports dealing with criminal justice issues, including most recently the previous Law Commission on bail, on custodial torture, wrongful prosecution, death penalty, etc. We are all, of course, aware of the Justice Verma Committee, which I just mentioned in the context of the 2012 rape homicide case. In 2003, the government had set up the Justice Malimath Committee, which had recommended many changes to the criminal laws. And once the current government took over for its second term in 2019, the Home Minister articulated his opinion that there was a need for criminal justice reform, and the issue came back into focus. So keeping this history in mind and recognizing, like I said, that criminal law reform is a evergreen topic, we plan to discuss and have a conversation amongst our panelists here on whether there's a need for criminal justice reforms, and also to discuss a few specific issues in the 90 minutes that we have for our conversation. So with that introduction, I would first ask a open, broad question to all our panelists here on whether you think there's a need at all for criminal justice reforms, and if you think there's such a need, maybe in around 5 to 7 minutes, if you could articulate what those changes should be if there's a requirement for change. So let me begin with requesting Justice Basant to take that question up.
Thank you, Mrinal. Let me at the outset congratulate the BIC for organizing a discussion on this. I have about 51 years of interaction with the system, and criminal law has always fascinated me. And then I keep repeating that criminal law is too serious a business to be left to the judges and the lawyers. Civil society has got to be interested. They ought to take interest in that. Otherwise, I don't think the law is going to change. In that view of the matter, I'm very, very happy that the BIC has initiated a discussion on the need for criminal law reforms. When you say that whether you need a reform, you ought to understand what is the purpose of the system. What is the purpose of the criminal justice system? Well, those students of political science will readily tell you that the very state, the concept of status, I give a lot of my rights, I surrender a lot of my rights to the state, I pay my taxes, but I expect two minimum things in return. Two sovereign duty discharged in return. And one is protect me against external aggression, and the second is protect me against internal disturbance. And the internal disturbance I would broadly classify is protect me against crimes. The state's primary duty, one of the primary duties, is to prevent crimes. Well, that is the traditional concept of the state. In the modern constitutional republic that we live in, with Article 21 looming large and spreading its tentacles all over, I have a right to enjoy my life. And enjoyment of life definitely includes freedom from crime and freedom from the threat of crime. Both are very important to me. So look at the traditional functions of the state and the modern, the knowledge society functions where you recognize fundamental right to life. You have a duty, the state has the duty to ensure that crimes are prevented. And therefore, I would put it broadly and say a crime-less state, a crime-free state is the utopian dream of the criminal justice system. If that is the dream, the next question is, do you think it requires reforms? How do you prevent crimes? How do you make sure that there are no crimes? I believe you refer to many things, what shall I say, not a planned response to the situation, but the knee-jerk reaction that come in the revision reform of the criminal law. You have the Matu case where all witnesses turn hostile, you cry horse. You have the Nirbhaya crime, you cry horse, change the entire law. They've all been cosmetic and myopic. There has not been a larger perception of what the criminal law ought to be. And if you want a crime-less, crime-free state, I believe people must be deterred from committing the crime. And to deter the crime, the severity of punishment is a very, very poor indicator to prevent crimes. You must all have heard of that great story, picking the pockets was becoming very, very usual. So they said we have to prevent this, and they said we will have a law which will say murder for the pickpockets. And then that was not going to be very effective. They thought we'll have a public execution of the criminals. And they all came to witness the public execution. By the time they went home, they found many of the pockets had already been picked in that public execution function. The severity of the crime, according to me, is not a sure indicator of a purpose or the effective functioning of the criminal justice system. I would think two things are very important. And when we talk of reform, that according to me is very important. One is certainty of punishment. There must be absolute certainty of punishment in the community, which will say, if you are guilty of crime today, if not tomorrow, the law will catch up and take you. So point number one, to ensure a crime-free state, which is the constitutional promise and the promise of the very constitution of the state, the first thing is certainty of punishment. The punishment must be certain. Second is, it must be immediate. There's no point in saying that the punishment will visit you after, say, 2 decades, 3 decades, as we see in the Supreme Court today. That's not the purpose at all. In order to deter the commission of crime, in order to attain a crime-free state, we must have two very important ingredients of certainty of punishment and immediateness. And I say immediate, I'll add a rider. Not that from the scene of the crime, the man should be dragged to the police station and from there to the jail. That's not the type of immediateness that I speak of. Our system is committed to the concepts of natural justice, audio outcome pattern, and therefore there must inevitably be a distance between the event and the response. And therefore, I'm not trying to. The lesser the time, the better for the system, and therefore immediateness and certainty would be important. Now, one more thing, and I'll stop it here. Now, see, what do you think should be the system? We have a lot of systems. We have the Anglo-Saxon system, we have the continental system. We ought to appreciate that the Indian system, we have the Islamic system of administration of criminal justice. To me, it doesn't matter. The cat should catch the mouse. Let the cat be black, white, brown, or a combination of everything, I don't care. But what it should do is, it must achieve its purpose. And the purpose is to travel towards a crime-free state. And that is the purpose. And therefore, one more step in. What is the law? Let it be whatever system, whatever jurisprudence that you have. Law must be the quintessence of the common sense of the community. Trained common sense, I'll add that. Quintessence of the trained common sense of the community. This is very important for me. Every law should have the fragrance of Mother Earth. It must be firmly planted in terra firma. There cannot be too much of a gap between the common sense of the community and the common sense of law. If that is there, the law gets discredited. And therefore, to me, it's very important that you must have a system of law which is in tune with the fragrance of Mother Earth, with terra firma. English system developed on its own. The Anglo-Saxon system had its own reasons and causes. We adopt the good in that, but it's time we start thinking that should we simply accept the system that has been left behind here by the British without questioning? I think it's time to question. It's time to introspect and find out, is it good for our system? Is it in tune with the native common sense of the community? If it is not there, I'm afraid we will have to show the boldness to change, alter, and reform. Well, I've been in the system for the last 50 years, I told you. 3 years as a law student, 15 years as a practitioner at the grassroots level, appearing even before the special honorary magistrates, and now before the bench of the Supreme Court. My experience is that. I would certainly think that it is for us to see what is the drama that goes on in our courts for a moment. I don't know how many of the laity will be aware of this. What is the drama that goes on in our court? I'll just quote one example and tell you. See, A comes and tells me that B has beaten him, right? A comes and tells me, sir, B has beaten me. What do? Do I call B and ask him, oh, B, did you do it? No. I ask A, produce evidence to show that B has beaten you. Well, it rebels against my common sense. The native common sense of the community, it rebels. I can understand the British with the English with their own experience with the system had reasons to do this. But for me, it is really shocking that the drama that goes on in my court every day is that I don't ask B whether you have beaten A, but I ask A, produce evidence to show that B has beaten you. I ask A or the state representing A to produce evidence to show that B has beaten me. Yes. And then poor A with the prosecutor frets and fumes and observes all procedures. And then he comes off A, then B says, I was not there at all. Plea of alibi. I was not there at all. Then the prosecutor frets and fumes and proves that A was there, B was there at the relevant time. Then B says, oh, you say you prove that I'm there. Okay, if I'm there, I did not beat you at all. Oh, then he frets and fumes and proves that B has beaten A. And then B says, oh, did I beat him? I must have done in self-defense. And the right to plead that I have a right to plead that I did it in self-defense. And if even that fails, the many decisions of the Supreme Court now say, you may have failed in your attempt to establish your plea of self-defense, but in attempting to do so, if you are thrown out on the initial case of the prosecution, then also you go scot-free. Well, this is what I think a certain amount of introspection and willingness to adapt to the native common sense of the community. You cannot be very different from the native common sense. This would definitely mean I am not interested in the cosmetic changes, a bail plea here or this, there, that. I'm not interested in a discussion like this. I think we must go to the more fundamentals. In 1973, when Krishna Iyer Commission suggested law reforms and the new Cr.P.C came, the profession, the enlightened in the profession expected a lot, that we will Indianize. Indianize may be a bad word in Indian politics. We will indigenize, I'll call it. We will indigenize and make law true to the quintessence of the common sense of the community. But it did not. It did not change at all. See the code before 73 and after 73. What is the fundamental change that has taken place? 75 years of independence. Still we find we have not changed the law at all. We are not customized it. We are not adapted it to our own requirements. And therefore, I believe, I think I've taken a little too much of time. What I would suggest is, unless we are willing to indigenize or make even the criminal law, attune the criminal law to the common sense of the community, the quintessence of the common sense of the community, and adapt necessary changes. Next part, maybe I'll go a little more details to try to say what I mean by adapt and bring in new concepts. No, it's important. No, it's important because I find the law, don't expect the lawyer to make any changes. I was introduced as a justice, but today I'm a lawyer. And when I say something about the lawyer, I'm only doing introspection. Don't expect the lawyer to come with changes. The changes will have to be forced on the system. Changes we'll have to force people to accept wholesome changes. That's all democracy is about. We will have to do that. And therefore, what changes, maybe what changes I have in mind, I'll reserve. But my point now on the initial thing is, not be content with cosmetic changes here and there. A bail provision here, and examination of accused provision here in its present. They're all only cosmetic. I want the system. I want people to think. I have wanted many places. At least one university take it up and say, instead of complaining about the inadequate procedure code that we have, come out with a suggestion for a revolutionary procedure code which will customize our requirements and change the law. Well, then therefore, I think we must be prepared to look at things, structural alterations and not mere cosmetic changes. That should be the theme of the discussion today. Maybe I'll come in the next spin that I have to explain in greater detail what changes might be helpful to the system. Thank you very much.
Thank you, Justice Basant. I think you've given us a lot to discuss, and I have specific issues also which we may want to discuss. So let's see how the discussion goes, and I'll come back to those specific questions. So, Ms. Pant, thank.
So, good evening, everyone. And let me first take this opportunity to thank BIC for making me panelist amongst such distinguished, actually, panelists. I'm really happy to be a part of this session today. And really great listening to Justice Basant and whatever points he has said. I completely agree with most of the things that he has said. There is no doubt that our criminal justice system does need a lot of reforms. So be it the laws, the entire criminal justice system, so be it the laws which are made by the legislature, or be it the law enforcement agencies, or be it the prosecution, be it the judiciary, or be it the correctional system. All the different components of the criminal justice system do need to be relooked into. The basis of Indian criminal law is IPC, which is an 1860 law. And as I mentioned, and as we all know, it was given by the British. So it is very important for us to change the laws in keeping it with the changing times. See, since then, a lot of things have changed in the society. The social structure, the economic structure, everything has changed in society. So the laws also need to change accordingly. So just to give you an example, the adultery law, or for instance, the rape law, with these laws need to be more gender neutral. So such changes are much needed. Also, one thing which I see as a practitioner of the criminal justice system, I believe that the laws, from a more practical point of view, I would say that we have multiplicity of laws, like too many minor laws, too many acts which have to be looked into. And for a practitioner, it becomes very difficult for us to adopt and actually use these laws in a correct way. So I think it is very important for us to consolidate all those hundreds of acts which are currently present and make them more user friendly. That's the word we use, be it the apps that we use or the websites that we use. We talk of the word user friendly. So our laws, the criminal justice laws, I do not think are very user friendly. So as a result, when a case comes to the police station, we may not end up using the correct law, because there are so many laws. We cannot expect a police personnel sitting in the police station to be aware of each and every law. It is a practical issue, and from my experience, I would want to include a lot of these laws in our IPC. For instance, the economic laws. There are a lot of economic offenses which are happening. There's hardly anything related to that in the IPC. So we need to have more consolidation in terms of the multiplicity of laws. And of course, another thing I would just like to add to what Justice Basant said regarding this native common sense. And I would like to just extend to what he said, in that, so you were giving the example of, when you have the victim and the accused in the court, and you ask the victim actually to give the proofs, which is fine. I believe our laws, definitely the kind of systems that we are seeing, and this might sound a little controversial because it is coming from a police personnel. We have to ensure that the innocent does not get punished. It is very, very important. At the same time, we have to ensure that the victims are given justice too. So while we are talking of the rights of the accused, it is very, very important, equally important for us to talk of the rights of the victim. So what I mean by that is, as Justice Basant said, justice delayed is justice denied. So when we talk of the rights of the victim, one thing, if we give justice to that person on time, we ensure that we actually help in ensuring the incidents of crimes come down, and also give justice to the person against whom wrong has been done. This is my this I would continue about other topics later, but I think I should give the next speaker the chance to speak. So that's it from my side.
Thank you. And I think the way we, again, for those listening in, the way we frame the discussion also is generally we end up um, saying that the rights of the accused versus the rights of the victim. It is not that the Constitution does not talk about rights of the accused versus the rights of the victim. And all of us, be it academics, police officers, judges, lawyers, end up trying to do that balancing. And I think framing is important. And so the balancing shouldn't happen. Everybody should have their rights. So the accused has 100% rights, the victim has 100% rights. So do witnesses. We forget witnesses in this entire process. Justice Basant mentioned about the witnesses being important. I don't know how many of you have been witnesses in court. Those of you listening in, you're treated so shabbily by the system, and as if you have no rights in the process. Why would you be interested in participating in the process at all? So I think it's important that we don't talk about balancing rights, but ensuring that everybody gets rights in the system. So on that note, Ms. Grover.
Thank you, Mrinal, and good evening to everyone. Thank you to BIC. As Justice Basant said, I think this is a very important discussion and should definitely not be confined to practitioners of law, as it involves everybody. I've had the privilege of listening to the other panelists, and so I would take the discussion forward from there. I do agree with some things that Justice Basant have said, and some have provoked further questions in me. For instance, I agree that we require substantive changes, and they cannot be piecemeal, and because of the absence of political will, we see piecemeal changes which need not necessarily bring the desired results. However, in the approach towards how we go forward in what is it that we are required to change. Just to take a few examples, I think there are some crimes which are not even codified in the Indian Penal Code or any other law. Yes, we have a plethora of laws, as Ms. Pant just pointed out. But perhaps there are still certain violations, discriminations which deserve criminalization but have not been criminalized. For instance, and we see people knocking the doors of high courts on this, sexual violence against transgender persons. It is in the city of Bangalore that PUCL many years ago brought out a report which laid bare the evidence of this. Do we have a provision which talks about sexual violence against transgender persons? We don't. So we do also need to look at what are the missing crimes. And one of my favorite examples, which usually people think I'm joking, I've actually never been more serious. Why is non-payment of minimum wage, whether to a domestic help or anybody else, not a crime under the Indian Penal Code? And does that ask us the question that what gets codified as a crime is also a question that we need to ask ourselves. The Indian Penal Code is a colonial code with many modifications, amendments we've made over the years through intervention and participation of society and parliament. What is the smallest chapter in the Indian Penal Code? It is crimes by public servants. I can understand that when it is a colonial code. Why is it that with a constitution where citizens are at the center of the constitution and fundamental rights are meant to curb the arbitrary and expansive power enjoyed by the state, that the accountability of the public servant till date remains minimal in terms of being held answerable for crimes committed with the kind of authority and power that they exercise. Whether it is in the time of outbreak of mass violence, whether it is in the times of custodial violence, you have severe gaps in law. And there are law commission reports to that effect repeatedly. Just to take one example, that we do not have today a comprehensive law against torture. We only have section 330, 331 of the Indian Penal Code, which talk about confessions extracted through torture for purposes of confession. Everything around us, including the egregious incident in Madurai last year, shows that torture can be committed for a range of reasons, and confessions may or may not be one of them. So my first point is we need to codify as citizens what are the crimes and violations that are being suffered. My second point is about accountability. And we need to look at the criminal laws as a whole, particularly procedure evidence and the Indian Penal Code, and shift the terms of the way it is structured, where legal immunity is provided. And I think it's high time we got rid of legal immunity. Good faith and legal immunity continue to be ubiquitous clauses right down to the pandemic provisions and the ordinances now on the anti-conversion laws, which is of colonial vintage. I don't see anyone saying that, when we want to get rid of the colonial legacies, why don't we get rid of these kind of colonial legacies and test it against the constitutional threshold? The question that I'm provoked to ask by hearing Justice Basant is that cat should catch the mouse. Is the mouse wrong? Why should the mouse be caught because it is puny and tiny and trying to run away? But more seriously, is there one common, uniform, scripted, native common sense in this country? A country that is hierarchical, stratified, diverse, plural, has multiple ways of existence. There are hierarchies of caste, of gender, of ethnicity. Can there be one native common sense on which we can rely to pull for ourselves principle? Or is that common sense already inscribed in the Constitution and we do not need to reinvent it anymore? And that common sense was inscribed in the Constitution because if we leave it to the native to just take that phrase of native common sense, can it unfortunately get distorted into a majoritarian common sense? Will it get articulated as a Khap Panchayat fiat against women? Will it express itself as an anti-Dalit opinion? I don't know. But these are cautions that we may wish to consider when we say, let it have the fragrance of our surroundings. Our surroundings we are in a garden of multiple blossoms. And we have tried to put together something in the Constitution. Perhaps this is not, the way forward is not to reinvent that, but to go back to those principles, the principles of equality, non-discrimination, accountability, which are not today guiding the codes or the exercise and the manner in which um, we have our criminal laws operating. I'll just move forward from there and quickly talk about a little bit, which I'm grateful to for what Mrinal mentioned, and I just want to repeat this. Uh, as somebody who works on women's rights and on child rights, rights of victim and rights of accused are not in collision with each other. This is a false binary. It's not what those of us who have been engaged with women's rights, both inside and outside the court, have ever asked for. It is the system and the processes that need to be put in place. The victims are not losing out because accused have rights. These are false binaries which are actually abdicating and taking away our attention from the flaws which are systemic in the criminal justice process. For instance, Ms. Pant, and I think there are some cliches that which have begun to, to just become part of our common sense and common language, and I think we need to sometimes pause to unpack them. For instance, when we say we want gender-neutral laws, which actually is what happens in the West, why do we want gender-neutral laws? What I would argue for, we want gender-specific laws. We need to recognize the distinct violence and violations suffered and experienced. Therefore, you need to give protection to everybody. And protection is not given by making everything uniform. So the kind of experience that a transgender person or a gay man may have with the criminal justice system or at a police station may be different. Maybe for a gay man, not disclosing identity is not the biggest issue. For a woman, it may be, because we have a society which has many prejudices. So we need to revisit where the protections are lacking through the specificities of those lenses, rather than offer neutrality, which actually would award barely anything to the one impacted. So my pitch here really would be that it's time to secure accountability from those who are in positions of power and authority. And to do that, whether it's the police or in the administration or any other place, it's about making the entire system answerable, rather than just having a process which says we have to get somebody, because who you will catch, the mouse in the system will be certain categories of persons. We will therefore have to reconfigure who is it that is committing the crimes and who the criminal justice system should be looking out for. I'll stop them, Mrinal.
Thank you. And I'm sorry to Justice Basant. I'm just going to make it a little more specific, because I fear that if we continue along the same line, we will end up discussing the Constitution, which is very important, of course, and very technical evidence thing, and we might lose our audience. Although I'm very interested in taking what all three of you have spoken into the next realm of discussion on things like presumptions and reverse honors clauses and the like. I think we'll lose our audience if we get into that. So maybe for another day. So I'm going to just pick up again what all three of you mentioned, and try a commonality of the themes that all three of you brought in, and let's discuss some of those issues. We have around 38 minutes into the session, so we have around 45 minutes. So keeping that time also in mind, I'm just going to look at particular issues. So I think one thing that came up with what all three of you said is the question of trials. And the trial, as Justice Basant put it, sometimes becomes a joke, a circus with all sorts of things coming into it. And in the process, like Ms. Pant mentioned, you have unnecessarily long and trials, which end up at the end of the day causing pain to everyone in the system, more probably the witnesses and the victims, if the accused is not in custody. So if the accused is in custody, that's a different thing altogether. But if not, it may cause an issue. But at the same time, whenever we have any incident that happens, and when we react, the first thing that is demanded is, let's have a fast track court, and that these fast track courts are seen as a solution to all problems. And then we go back to the next step, saying, okay, if the fast track courts are doing these things quickly, why don't we convert all courts into so-called fast track courts? So I want to take up that question of your experiences with so-called fast tracking, and whether you think fast tracking of trials is a way to deal with the endemic delays in the system, or is there something else that's uh, happening in the system that is actually leading to trials getting delayed? And the first thing I would say is we need to define delay. So the other question would be, is there a delay at all? Should it take that much time for a criminal, say a trial for a serious offense to actually, it should take 2 years. It's fine if it takes 2 years. And we are demanding too much if we say that, it should be finished. Like I remember it happened in Madhya Pradesh after 2013, 6 days, 7 days of charge sheet, 10 days, where the 15 days is the conviction, and by the third month, the High Court has upheld the conviction, right? And only for the Supreme Court to acquit everyone, saying the process was not properly followed. So on that, I'll ask Ms. Pant first here, from a perspective of your perspective in this context.
See, as I said, definitely we would want to have, you know, mm, faster trials. Though I really think that, trials which end in 15 days, 20 days may not be very effective, because as we know, the process of evaluating the evidences, that itself requires time. And especially if we are talking about scientific evidences, and we are talking about electronic evidences and all those, which I think for a lot of our judges, these things are also relatively new. To understand these things and to process them in the correct way and then take a decision definitely will require time. And as we are seeing in more and more cases, we are using more of electronic and forensic evidences. So in that sense, I think there should be uh, there should be reasonable time. We cannot have unreasonable 15 days, 20 days. That is absolutely not giving justice to anybody. So as we said, and as you also said, we all agree to that justice is not just for the victim, but also if the accused is innocent. So, in that case, I think it is very important to have a reasonable time. That is something that we can decide. Like, for instance, in our charge sheet, when we are required to file charge sheet, there is a time limit which is fixed, which is quite reasonable. And if there is, if we need more time, then we seek time from the court. So there can be some kind of a reasonable time limit that can be fixed, that can be based on the kind of cases which have been, the courts have enough data to sieve through and to have this reasonable time limit for different kind of cases, which will definitely help the entire criminal justice system and give justice to the people. So this is what I think.
Sure, Ms. Grover?
So as far as fast track court is concerned, in my experience, actually, it's just a myth. And it is something that is peddled out by governments and politicians because people are enraged and angry and traumatized. But it doesn't work. It's not worked anywhere. I've had the experience of appearing in a fast track court in a district in Uttar Pradesh in cases where we were told there are 3 fast track courts set up. Actually, the judge was transferred and the position lay vacant for the next 6 months. So fast track courts judge can just be transferred out. And this is not a unique experience. I did research in Chhattisgarh, and there, for some reason, somebody's got transferred, and there was finally only one fast track court which had more work than the regular court, because all the fast track court cases had to come to that court. So I think we are constantly trying to work with a system which has collapsed in multiple parts. And then we keep trying little band-aid solutions, which don't work and will not work. And very importantly, where we need to focus, and this is something, again, I've said very often, when the budget is presented, please look at what is the allocation being made to the legal system and what is the allocation being made to other branches of the system. If your allocation to the legal system is going to be so paltry, and very, very little of that trickles down, and Justice Basant would know way more than me, trickles down to your district courts and trial courts where the trials are taking place. You are not, the fast track court is not going to provide any service at all of fulfilling anybody's need for a speedy justice. Having said which is a systemic issue, so hopefully when the budget is announced, we pay some attention to the allocation being done. The second part about this, and I think some states, Ms. Pant may know more, have actually passed laws now which say that in cases of rape of a minor girl or a minor, you will finish the investigation in 15 days or 30 days, and then trials are going to be finished. We've had 309 in the Cr.P.C forever. No trial gets finished, and rightly so. There you will have to give reasonable time. Of course, when lawyers are playing hooky, and we all do, we will confess to that. Judges have the power to tell us we are not granting adjournment. Judges can see right through the games a lawyer is playing, and the lawyer needs to be pulled up and not allowed to play those games in a court of law. But reducing the time for investigation is actually going to hurt the case, because there is no power on earth that the police is going to perhaps be able to collect everything in a week. So either you're going to get the wrong person because there is pressure, or you're going to get scanty evidence and patchy evidence which will not withstand scrutiny. So I don't know whose purpose is being served. Having said which, I think there are also cases where there is deliberate delay. And that part, again, it is for the constitutional courts to pay attention to. I will take 3 examples here. One is a case in which I'm currently appearing of some in a Delhi riot where a video went viral. We see some men being beaten by the police, and one man is dead. The incident has taken place in February of 2020. We are in January of 2021. A charge sheet is not filed because the Cr.P.C's mandate of limitation comes in only when there is somebody in custody. Otherwise, there is no law. And I'm not at all suggesting there should be, that there will be a timeline and after which no charge sheet can be filed, because that will be counterintuitive altogether. However, because the accused, and the police has said so in one of its status reports, are bound to be policemen, there is no charge sheet. We are 11 months down. It's going to be his death anniversary next month. When will there be a charge sheet? Who will ensure that this kind of delay doesn't happen? And if people are in custody, as in say the Bhima Koregaon case, since June of 2018, you can file charge sheets, you can file supplementary charge sheets. Investigation can continue because there is some criminal conspiracy. There is no bail being granted. There is no trial commencing. Here one will also, there are multiple issues at stake. We will have to look at different scenarios to come to some kind of answers here.
Thank you. Justice Basant, before I get that same question to you, I also there's a question in the chat in the Q&A box which sort of talks about the same issue where one of the attendees is asking that in cases of people with political influence or economic backing being the accused, don't you think it's possible that if the trial goes on longer, it's easier for them to get rid of evidence or bribe or get rid of witnesses? And how do you tackle something like this? So I peg on that question to you because you have such vast experience also as a judge. How would you deal with an issue like that?
Mrinal, as perhaps Ms. Grover said, this fast track is a misnomer. It's the same track. There's no different procedure prescribed for a fast track court case. See, sometimes it's politically very rewarding to use big names and then, shall I say, befool the public. What is a fast track court? Is there a different procedure prescribed for a fast track court? We don't have sufficient number of courts, and therefore we get some more courts and call them fast track courts. A track becomes different, a track becomes faster when there's a different procedure prescribed. It's not there. Let's understand it very clearly. The fast track courts were only a mechanism by which the number of courts were increased all on a sudden, right? And then, of course, judiciary found out a method by which they said ripe cases alone will go to the fast track court. You understand? The cases which are ripe for trial, they alone need go to the, so that procedural delays for completion of investigation, etc., will not be there. But for this, there is absolutely no difference in the track and a fast track court. It's the same. When the name is very attractive, isn't it? Fast track court. You think it's a wonderful thing that's happening. It is not. People who are in the know of things will realize that it is not there. But there is a point, I always feel that. See, a court, supposing a case requires, say, 2 days. Today the case comes to me. If I give him those 2 days now, probably it's over. But what I tell him is, please wait for the next 5 years, I'll give these 2 days to you. Well, that's the problem, really. That's the problem that I find so far as the present system is concerned. We are not able to allot to a court the time it requires today or tomorrow. We are asking him to come days, months, years later. That is a very, very crucial part of the delay process. Another thing that I find is, if you have the same procedures, you will never be up to date. Take it from me, my experience tells me that if this is the type of trial that you're going on, just one example, there is a traffic accident case, right? A negligent driving of a vehicle resulting in injury to a person. What is the prosecutor supposed to prove? First, the car was his, for that you produce documents. He was driving the car. What is the harm if you ask him, what is your defense? See, natural justice involves a power to be heard, a right to be heard. Now, if that is where does testimonial compulsion come in at all? This is why perhaps I wanted on a larger area to say, unless you modify the procedures and customize it to the native common sense, I'm afraid I sent a wrong message by saying, my native common sense of a modern Indian is a common sense which is acceptable to all. I don't have a Dalit common sense. I don't have the forward common sense, backward common sense. No. The Indian common sense, the Indian native common sense is definitely controlled by the equality provisions of the Constitution, by the constitutional morality, we may call it so, in tune with the modern thinking. I'm not talking about, and the mouse thing example was also not most powerful. Prevent the crime, that is the every system must have a purpose, and that purpose must be achieved. And it's only in that context that I spoke of the mouse and the cat. I really believe that. The point that I want to make is, yes, Now you ask me one more specific question. What about the politicians? Supreme Court has seized to the matter. The Supreme Court has directed all the states to constitute courts which will take up cases of the politicians, where politicians are involved. It's a two-way process. Politicians are also sometimes at pressed because what happens is their cases are not taken up. They have political stakes involved. They're not able to fight their work their way up in the political scenes, and therefore that's also important. So you are right that the public perception is powerful people get away, and to prevent that, the Supreme Court has now said that this has to be done. To me, all these are cosmetic exercises. Until you really address yourself to the core issue or the procedures to be done, and really fast track the procedure, until then it's not. There's a very admirable thinking which says all so-called criminal cases need not end in prison. And therefore, you can have a certain set of cases, criminal cases, of course, where which the fine or compensation would be sufficient, take them away from the normal the trial procedure, put it across elsewhere, visit them with compensation or penalties, and that need not go through all the rigmarole of procedure in the deprivation of liberty cases, imprisonment cases. And therefore, it's perfectly possible there are many cases in the IPC which are punishable with fine only. Why don't we declassify them or take them away from the mainstream of criminal cases, which would end in mandatory imprisonment or more serious criminal cases, and set it apart where all the glorious theories about right to silence, plead or not plead, the conflicting pleas, all that would go. It could be resolved in a penalty procedure, so that the burden on the system will have to be reduced and the procedures will have to be quickened to structurally altered to ensure that the trial does not take so much of time. In an accident case, I have always seen at the end, when it comes to the Supreme Court, I point out to the Supreme Court, oh, Cr.P.C, there is no evidence as to who was driving the vehicle at the relevant time. And then when you look at it, you find there is no evidence. That is because the procedures are such that you place all the burden on the prosecution and say that from A to Z you prove. What is the harm? If a show cause notice is issued to the accused, he is given opportunity to respond to it leisurely, and then only what is disputed alone need be adduced in evidence. Evidence need be let in only for that. This is where I think fundamentally different approaches, innovations may be necessary. Not a fast call a court and call it a fast track court, call another court and call it a very fast track court. It is not going to help you at all. I am thoroughly dissatisfied with these experiments that are going. Yes, they are relevant because you are trying to get sufficient number of judges, right? Very good, very good. That's wonderful. You all know that in a common cause case, Vrinda must be able to tell them. In a common cause case, the court said, cases which have been dragging on for quite some time, let us bury it so that the system is relieved of the pressure of work. But of course, later the Supreme Court changed it. So something like that will have to be invented to see that today's case is taken up tomorrow and not 4 years later. That is where we need innovation. That is where we need bold innovation, if I may call it so, and make sure that the procedure, the essential procedures are so fashioned so that the unnecessary time consumed. See, our criminal justice system is framed in how many years? There we have all the time in the world. The state was all powerful, much more powerful than the offender. And the offender could remain there with his glorious right to silence. As I told you, I may plead, I may not plead. I may plead, I may take a contradictory plea. You prove everything against me. Gone are those days. I don't think we can have the luxury of a complicated game where rules are more important than the end result. It's only then that the real fast track courts will come. Unless you fast track the procedure, putting them a big board of fast track court is not going to help you at all. This is my appreciation.
Thank you, Justice Basant. I think from a point of view of an academic, I think something that I've looked at and studied, it's again very clear that I think there's one instance where all special courts, all fast track courts were being put to additional sessions judge 1. ASJ 01 across states, across cities. So the poor ASJ 01 was fast track and special court for everything, for every legislation, fast track. So then everything would then become slow track, because if that judge has 1,000 cases, his colleague has 25, and you're expecting the one with 1,000 to fast track, and probably the one with 25 is being able to actually do it in a much better way. And I think the earlier point also that I had said on defining what delay is, because at least some of my work, I don't think it's fair to say that criminal trials are delayed, because criminal trials across, in some states there are, can't generalize for the country, but if you were to say that a murder trial should be finished in very quick time for 6 months, 8 months, when you have 400 witnesses and things like that, I think we're being unfair to the judges also to say finish this very quickly. But like the person who had asked the question, yeah, it is definitely an issue of how do you ensure that your evidence actually stays by the time you go to trial. And there's a misconception which sometimes people jump in saying, oh, in the US or in the UK, the trial ends very quickly. It doesn't. They take up the trial 2 years after the incident, and then they go day to day. Of course, the Cr.P.C also says we should have day-to-day trials, which we have not been able to do. But then you go day to day and complete it. But that issue does arise of if you're going to actually start a trial 2 years from now and without having a witness and victim protection system, uh, obviously the witness is going to be threatened, and 2 years down the line the witness might say nothing happened, I didn't see anything. So I think, again, like Justice Basant was saying, some of these things we completely ignore. We ignore the fact that we have not made any structural changes with respect to witness or victim protection, and we just make cosmetic changes like this of bringing in fast track courts, which will all end in 100% acquittal. And then you say fast track courts have failed, so we need something else, and then you add more and more provisions, and everything fails one after the other. So I think there is a need for some more principled thinking on some of these issues rather than cosmetic changes. Okay, we're at 7 o'clock, so we have around half an hour. So what I'm going to do now is I'm going to ask specific questions to specific panelists. I'm also trying to gauge interest from the Q&A box to try and see what are the type of questions that are coming up, and using that I will ask particular questions. So Ms. Pant first, because you mentioned during one of your comments about things that are not criminalized in the context of, say, economic crimes or cyber crimes. So could you tell us about, again, what more needs to be criminalized? And I think on one end of the spectrum is over-criminalization, where we criminalize things that should not be criminalized. But like Ms. Pant was saying, we have things that should be a crime but are not. Could you address that question on something like, say, cyber crimes, which are on the rise, which Bangalore police has been doing a lot to educate people about, but is there something more that we need to do in terms of legislation on some of these issues and things that are not criminalized and need to be criminalized?
Yeah. Cybercrime, if we talk about cybercrime is one field which will keep evolving, and we are seeing new kinds of cybercrime on a daily basis. Though, after 2000, our IT Act has been amended, but we do need more amendments because, as I said, we are seeing new kinds of cybercrime on a regular basis. So, there is, and the kind of cybercrime, like now we are seeing cybercrime which is happening not within the confines of India. So we have people from different parts of the world who are committing cybercrime here in India. So I think we need to have a more international approach when it comes to the cyber crimes and the cyber laws in India. more collaboration with other countries. I think that is extremely important because the losses that we are talking about here in, in the cyber crimes, it's huge. It's huge. Like, I'll just give you an example. In Bangalore city, we have started something called as a cybercrime incident report. So this is essentially like people will call and give a complaint to Bangalore City Police on the phone. This is similar to the National Cybercrime Reporting Portal, except for in the portal you have to register the complaint online. Here you can register the complaint on the phone. So you dial 100, and then you are connected to to an operator who will take all your details, and then we will do a brief investigation, and then we will take immediate actions, because immediate actions in cyber crimes is very, very important. This concept of golden period, that is very important. So here, this is done only in for Bangalore city. But here also we are seeing, the kind of losses people are facing is huge. So I think it's very, very important. And criminals are throughout the country. And also in one of the cases, we had a Nigerian, it's been only 20 days, but we are already seeing cross-border crimes which are happening. So it is, as I said, it is important in that respect to have more of an international, perspective to this, and more international collaboration when it comes to cybercrime. Secondly, when it comes to cybercrime, our IT law is not very, very clear on cyber war, which I think, we are seeing more and more. And so we need to have clear laws when it comes to cyber warfare, because the law enforcement agencies, the agency which is responsible to take action on these complaints, we ourselves are not very clear about the steps that need to be taken in case of such incidents coming. So cyber war is not is a very broad concept. It's not just a country specifically attacking another country. It is more about somebody outside who is supported maybe from another foreign country. They are expressly targeting the residents or the citizens of a particular country. So in that sense, when we talk of any kind of cyber crime which is happening, which is involving big companies, or which is involving a large number of people, that also comes under this purview. So we need to understand the broad scale of cyber war, and we need to have clearer laws on cyber laws as well. This is regarding cyber, but I would also like to talk briefly about the kind of changes we need in the law. Like when I spoke of gender neutral laws, I mean, definitely what I actually meant was, I was very, very specific, in terms of rape laws. Rape laws, the definition of rape, it specifically mentions man committing this crime against a woman, which I think is, we need to get rid of that. Rape can be committed against anybody, as you correctly pointed, Mrs. Vrinda Grover, that it can be committed against a man, it can be committed against a transgender, anybody for that matter. So it is very important for us to include these provisions in the law, which right now we do not see. At the same time, I always have problem with this adultery law, where only a man can commit adultery.
That's been struck down. No, it's been struck down recently.
Okay. Yeah.
497 has been struck down
I
by the
think
Supreme
I'm
Court.
not very aware, and I'm sorry.
Yeah.
But but when I spoke of the rape law, this is what I meant, and that's what I meant when I say gender neutral laws. And definitely, I am not trying to paint everything in one brush, but there are different provisions, and maybe there are certain laws which need to be maybe gender specific, which need to be specific to certain sections of the society. But by gender law, by gender neutral law, I meant specifically the rape law in our country, which needs to be more widened. Uh, so yeah.
Great, thank you. I'll respond to the last bit on the gender neutral laws because it's something I've worked on, and also it was something that the Verma Committee had looked at in quite a bit of detail the entire 1 month. If you read Justice Leela Seth's book, and she describes in the first chapter how the entire 30 days was spent on this question. And in fact, as you know, the Justice Verma Committee had recommended that the victim be made gender neutral, recognizing the fact that sexual violence happens against men, women, transgenders, and anyone who identifies themselves not as a man or a woman, but it went back to gender specific victim because, again, in the political spectrum at that time, it was with the elections coming up, you wanted laws which so-called protect women, and so that was how it was framed. So I think the Verma Committee was quite clear that you needed to make the victim at least gender neutral, right? And I think on that question, again, we can have a debate for the next 1.5 hours. So I'm not going to go into that, but I'm going to take two questions with something that I also wanted to ask. And two of our viewers of the panel have asked a question on arrests and also in the context of special criminal laws. So I want to ask Ms. Grover that question on the question of arbitrary arrests. We've seen so many changes made to the law, Cr.P.C being changed to say arrests are not necessary if the offense is not punishable with less than 7 years. Uh, then we have these special laws which change that framework. And at the same time, I know lawyers and judges have said that 7-year provision doesn't work because say something like cheating. You might have cheated someone of crores of rupees, but the punishment is less than 7 years. So I need to arrest that person because otherwise they are going to tamper with the evidence. So how do we deal with this issue of both unnecessary arrests and special laws which sort of increase that remand period, etc.?
I think the issue of rampant arrest, wanton arrest, arbitrary arrest is actually a very, very serious problem in the country today. And I think it's really, uh, while the responsibility of changing to some extent would be on the police leadership as well as the courts, it also depends on how public opinion shapes itself. Because there is also a lot of playing to what is being asked for. And we saw that, for instance, in the Disha encounter killings in Hyderabad, where actually they cited delay of the criminal justice system to say that we have got rid of accused suspects. Nobody knows whether they raped or not. I don't know how the police came to that conclusion in a day and a half. And literally usurping the criminal justice system's role and handing it over to the police and being applauded by the public. And it's all being done very cleverly in the name of protecting women. And that's not going to ever give freedom to any woman, and we know that. What is happening with the rest? Let's take a couple of examples to understand this. The UP ordinance on unlawful prohibition of unlawful conversions. Anti-conversion laws are not new. We've had them in Madhya Pradesh, Odisha. Fraudulent, forcible, coerced conversions must be prohibited. There is no dispute with that. Yet we saw that within 1 month, there was a spate of arrests which the police itself has gone to the court saying, sorry, these were just people. All they did was that they fell in love with somebody from another religion. I mean, this is what people are getting arrested. Just as Basant spoke about, and I really think that's a very appealing idea about how we need to bring certain offenses only in the category of fines, bring them out of the purview of punishment, and there can be a set of crimes. What are we criminalizing today through action of the police and the courts? And we are burdening the system with that. And then we wonder where all these cases came from. The police may have gone today and told the court at the stage of bail, but mind you, that case has gone into your legal pipeline. It's going to now go through the criminal justice system unless somebody looks at the laws and the evidence straight in the face and throws it out at the stage of cognizance, at the stage of discharge. Will it happen? Will it not? We'll wait to see. But that is the manner in which our system is running amok today. Sedition is another provision for which anybody and everybody can today get arrested. I may say something here which somebody may consider seditious, it may rankle somebody's sentiments, and it's such a subjective interpretation. So we have actually ways in which this arbitrariness has actually been given an impetus. And unfortunately, we are not seeing clear signal coming either from the court or from the police leadership, which clamps down on somebody who does this. So if a police officer makes an arbitrary arrest, when a woman is saying, I'm an adult, I'm going with this man of my own free will, yet they are being dragged to the police station, they are being imprisoned. What happens in the police system? Is there disciplinary action? No. Is anybody taken to task? No. Do the courts say, I am going to ensure that this particular police officer learns how to read the law in a case of sedition? No. So why? Where is the check and balance going to work from? Who is restraining arbitrary arrests? And therefore, when you're seeing your under trial population in prisons is collapsing, your criminal justice system is collapsing, there are reasons why this is happening. Do we need that in society today? Is really that what is causing the biggest issues of concern? There are serious crimes taking place. Who is spending, investing resources and energy in it? I don't know. So how do we stop these kind of arbitrary arrests? Somebody has to be made answerable when they do this. We don't see that happening. So we've got ourselves into a very peculiar cycle of things. So and we are pushing more and more laws with wider and wider. Either courts put down and prescribe, or the police prescribes, or somebody trains these people to say, well, the law is fine, somebody is reading it wrong. When many people are reading it wrong, and you have 55 arrests in 1 month, out of which only 14, even the police is today saying, may merit any consideration, then something is wrong in this system. This is not a reading of the law. This is an abuse of power that is taking place. And every single arbitrary arrest does not lead to any consequence in this country. Who is going to come back to sue for malicious prosecution, damages? Will we as lawyers tell anybody to go that route? No. So you have an entire system which is ballooning and bursting. And then we try and do quick fix. And then we say, okay, let's lower the threshold. Let's not give a complete presumption of innocence. Due process needs to be abridged. The answer lies perhaps elsewhere. So let's ask our tough answers, hold people to task. Let the politicians do what they're doing. Let us not get entangled in it.
Thank you. And I suppose you saw the 3 questions on sedition, and or I don't know whether you did. No.
No, I didn't.
So there were 3 or 4 questions where people are asking on sedition, which is why I thought you also went in that direction, but it was good you went there, because otherwise I would have asked that question back again. So we have saved time in that. But I'm going to take a part of that question to Justice Basant, in the context of the role of the judiciary. Some of the viewers have asked questions on especially on something like sedition, where we have the Supreme Court very clearly saying what are the ingredients of the offense are. And so the question is, if it's clear of what the ingredients of the offense are, why are these cases, why the people, to put it in legal terms, why are magistrates remanding to custody? Why is cognizance being taken, and then at the charging stage, there's no charge, but in that interim, the person's probably been in prison for 2 or 3 years. And if you look at the statistics of the National Crime Records Bureau, we see a set of offenses, like for instance, the entire chapter on offenses against religion in the Indian Penal Code has very high arrest rate, but but it does charge sheeting rate is on the other end of the spectrum. It's on the lowest charge sheeting, which means that the time between arrest and charge sheet, the person is in custody. There's no charge sheet, of course. The person is then released. But what is the role of the judiciary, especially of our magistrates, in this context, and how is there something that needs to be done to make the judiciary actually act on some of these issues?
Well, someone who knows the nuances of procedure would readily accept that the magistrates have a great role in preventing malicious, undeserved arrests. There's no doubt about it. Well, a good magistrate, an alert magistrate, can prevent a lot of unnecessary arrests, or at least the consequences of unnecessary arrests, by readily granting bail. But if you are aware of the nuances of procedure, you will find it's not black or white at that stage at all. It's very difficult at that stage to make out. They remain only in the realm of allegations at that point of time, and it becomes very, very difficult for a court to really understand whether it's a case where further detention is necessary or not. And that invariably explains the time that is taken. It's very easy now to sit here and say that the magistrate must alertly identify those false cases vis-a-vis the correct cases. But at that stage, they're not having materials at all. At that stage, they're having only allegations raised against them. And therefore, all sorts of oral statements could have been recorded. And the magistrates are definitely on the back foot in a situation like that. The famous statement, bail and not bail. The times that we have gone far, far, far away from those days. And I find that today, many offenses are made very draconian. Bail is very, very difficult for them. And therefore, the allegations alone matter. And therefore, you can always say an alert magistrate can. But it will be very difficult at that stage to discern an incorrect allegation from a real allegation, a bona fide allegation from a mala fide allegation at that stage, because only allegations count at that stage. Well, I would think that true to the liberty sentiments of the Constitution, more and more offenses should be perhaps made non-cognizable, where the police will not have a power to arrest a person. Now, see, advanced, you must have, as an academic, you must have known that in many of the foreign jurisprudences, arrest is the last step in investigation. Arrest comes as the very last step in investigation. Whereas an average Indian investigator starts with the arrest. He just looks at the allegations and arrests. And then the investigation comes post-arrest. Well, a society wedded to rule of law, a society with a commitment to individual liberty, ought to reverse this trend and make sure, see, I think there must be 101 ways of doing it if the legislature wants it. a police officer can issue a notice to them not to leave a certain jurisdiction. He need not be arrested. He can be asked to appear for interrogation. Now, all these, a whole lot of suggestions can be made if you want to make sure that this unnecessary arrest is avoided. You spoke of accountability also. Well, supposing there is a law which says a police officer, before he effects arrest, must record all the reasons which prompt him to make an arrest. Well, even in the ordinary thing, we insist on reasoned orders. On such a crucial aspect as a deprivation of liberty of a person by his arrest, why not we insist that the police officer should make a proper record of why arrest, a written order before he makes an arrest? Well, then accountability becomes much easier. Now, all the allegations that I can see in a remand report is such and such allegations are made. Allegations are very serious in nature. They deserve thorough investigation and hence give him custody. This is what is happening. This is what is happening. And you know, along with that, I will also say, I thought Ms. Pant will be highlighting on that. The police today is perhaps the most deprived of legal powers. Abuser has a lot of options, but an honest police officer who functions is really, really difficult. The system distrusts him completely. You know that. You know, I think an honest, a sincere police officer would lament and they say this. See, the police officer cannot even record the statement of a witness and get a signature in that. The 161 bars that. Forget about the accused. Forget about the indictee. Even a witness, you can't get a statement recorded and signed by him. The English system has traveled far, far, far. He trusts his Bobby. American system has traveled far, far from that. He trusts his Pope. After administering the Miranda caution, even the confession of an accused can be recorded by the police there. Whereas my police lives on a perpetual diet of distrust. Nobody trusts him. He can write whatever he wants in the case diary. Who's going to take him seriously? Well, trust and responsibility are two sides of the same coin. You trust a person, you get back responsibility. You don't trust him at all, he will never be responsible. For a moment, I'm not saying that the police as of today is trustable. I'm not saying that. But after 75 years of independence, if you can't cultivate, develop, nurture an honest police force which can be trusted, at least subject to very strict conditions, where are we heading? What are we doing? Well, are we going to perpetually live on a diet of distrust against the police, who are as much part of the system? There are 101 ways of ensuring that responsibility goes into them. These are all possible. We don't try. We want to live on the imperial English administrators did not want to trust the Indian police. They're trusting theirs, but they're not trusting ours. And we also continue not to trust ours. And therefore, it's a very vicious circle, you know, because you give more powers to the police, it is more abused. We have not been able to cultivate good police leadership, as she said, and we have not been able to develop. You know, the Prakash Singh case, how many times they said separate investigation from law and order. Let investigation be a specialized job, a very responsible job, and leave it only to a very respectable and new brand police force that is emerging. It's not there at all. I think we are very happy without any innovation, continuing the way the British has left 75 years back. That is why I keep on repeating that structural alterations are required. Don't start trusting them today, but subject to safeguards, start trusting them. Let investigation be by a special machinery who can do that. Arrest is one of the most vital things in a society wedded to rule of law and which values liberty. And how are we dealing with the problem today? That is why you bring up the question of undeserved, unjustified arrest. Well, to discipline the police force today, I think more and more offenses will have to go to the realm of non-cognizable, where they cannot arrest. And even there, they must be given provision so that the man does not abscond. You can serve a notice on him not to leave the jurisdiction on so and so. If he leaves, only the arrest can follow. Well, see, as Vrinda perhaps said, the question is one of accountability. We have got to cultivate a police force which can take up this newfound task of a police force in a country wedded to rule of law where liberty is respected. It's a two-way process. You have to trust him, at the same time make sure that it is not abused. All right, that this thought is uppermost in my mind because you don't trust your police force at all. Not that they are trustable now, I repeat. Every time I say this, there is a big problem. People say you have been in the system for 50 years. Do you not understand the small window of Section 27 Evidence Act? How much they abuse it, and still you are asking for giving more powers to the police? I am not saying that powers be given to them now and here, but there must be a change of culture where the police force in a democratic country wedded to rule of law in a constitutional republic must also be duly respected to discharge their function. Well, that is where perhaps the change of law, I don't think we have time to look at the change of law aspects that I wanted to, maybe some other time, it is possible. I always say Indian legal ingenuity is not found wanting. You can do that. You can do that. Let us all sit together for a month. We can suggest sterling examples of how the law can be made vital, very functional, effective. We can do that. But we don't want to do that. Why? We go by the principle of stare decisis. Stay where you are. Never change. Never change. And the parliaments, the legislative houses do not have the time for this sort of irrelevant things for him. They are much more attractive, things to do, and therefore they also do not worry about it. See, I was perhaps happy when the ministers, the home minister, said we have to revamp the criminal laws. I was looking at it in a very positive way, and I have read the amount of criticism that is coming against that. That a change should be there, I welcome. How the change is to be brought about, there must be better methods of doing that. Right, that's all there.
I think I just want to add, in the context of bail laws, I think we had recent judgment of Arnab Manoranjan Goswami of Justice Dhananjay Chandrachud, where he brings back everything that has been said in bail law jurisprudence for the last 40 years, starting with Justice Krishna Iyer in the 70s. And I think if you go back to Justice Krishna Iyer's judgments, we see that he clearly points out that we are on the wrong principle when it comes to bail itself, because our assumption is that if someone were to put in bail in terms of monetary bail or in terms of land or things that we require, that means they will not abscond. So in the process, one, you're bringing value to someone who has land, someone who has money, and so therefore it creates that sort of discriminatory situation. One, and second, Justice Krishna Iyer also in the 1970s refers to studies done in New York by talking about how people are really not absconding. So it is a misnomer that or a misunderstanding that people are absconding, and so you're tightening your bail laws, and this is in the context of the US. Of course, the US also didn't change, neither did we in India. So you end up in that vicious circle. And I think those of you who have Netflix should watch a documentary called 13th. It is on the 13th Amendment to the US Constitution to abolish slavery and due process, etc. And in that context, it shows how the criminal justice system can become a discriminatory tool in the hands of governments who think they're being progressive also. Like if the entire situation of criminal justice reform happened during the Clinton era, right, Democrat government in the US. So I think it's interesting to see again the parallels that we have in the context of some of these laws. And similarly, Justice Basant was talking about non-cognizable offenses and looking at other ways to deal with with crime and punishment. Of course, Justice Basant is from Kerala, and he is in Kerala right now. I think Kerala is the only state in India, if I'm not wrong, where the Probation of Offenders Act is something that was taken a bit seriously. Probation officers were appointed, uh, and so I don't know how much it's being implemented still, but at least on paper, Kerala was the only state which had it, which is thinking differently, saying it's not about custodial, it's not about custody in all cases. It's not about just imprisoning people. We need to look at various offenses in different ways and figure out different solutions to the multiple problems that we have in the society. And again, going back to the broader context of are we over criminalizing? Are we making things that should not, like Ms. Pant was pointing out, should adultery ever have been an offense in the penal code until the Supreme Court struck it down recently? And there's something else which should be an offense, but it's not. And again, going back to Justice Basant and the entire colonial understanding, if you look at punishments in offense against property in the IPC, we have life imprisonment for detonating a railway track. If I'm using an explosive near a railway track, because of course the railways was something that the British used to move troops and supplies across the country. So doing anything against a railway track was considered a big offense, but not equal punishments for something else. So I think these are broader issues for which we don't have time to discuss. We probably can take an entire day discussing some of these issues or more. So I, at this juncture, thank Justice Basant, Ms. Pant, and Ms. Grover for this very interesting discussion we've had, and the Bangalore International Center for organizing this. Thanks a lot.
To hear only four approaches and perspectives where the possibilities could be diverse and in tens and hundreds on an issue as wide as the criminal justice system has been an immensely eye-opening primer for us citizens who may not be versed with the law or have any concrete opinions. Your time, your candidness, and for sharing your views, Justice Basant, Ms. Grover, Ms. Pant. Thank you, Mrinal, for structuring the session and for your expert moderation. Thanks to Tala Salaria for helping us putting together this session. Thank you to the audience who joined us today. And good night, everyone, and see you next time.
Thank you. Thank you.